Chapter 3 of UCC Sales discusses the scope of Article 2. I'm going to skip the chapter problem, but there is a flow diagram on page 25 of my book showing that transaction in goods is defined at 2-102, and there's an arrow pointing to a flow chart. Next step in that flow is goods movable at the time of identification, and 2-105, and the definition of identification as used in the definition of goods. Then there is an arrow to whether or not it's a mixed contract, which stands for the sale of goods or the sale of services. If yes, a test is required. If no, and the answer is that there are pure goods or severable goods attached to realty, then the conclusion is either Article 2 applies to pure goods sales, or if the answer is no, then common law rules apply. The predominant purpose test determines if a mixed contract is predominantly for the sale of goods or for the sale of services, and that will be discussed, but that determination arrives at the same conclusions whether Article 2 applies or common law rules apply. Part 1, the importance of analyzing scope. To analyze a legal problem, the first thing a lawyer should do is determine the body of law that provides the appropriate rules for the analysis. The client does not walk into a lawyer's office and say, "Hello, I have a sales problem." Accordingly, this book begins by studying the scope of Article 2. When does Article 2 govern the legal analysis of a specific problem? As you learn in Chapter 2, many statutes contain a scope section that helps the lawyer determine whether the statutes apply to the problem at hand. UCC Article 2 is no exception. Section 2-102 is Article 2's basic scope section. In addition, as Figure 3-2 illustrates, a full scope analysis requires students to link up a number of other code sections. Students must also learn the definitions listed in Figure 3-3, which consist of transaction, goods, predominant purpose test, and gravamen test. Merchants in 2-104, goods, future goods, and identification in 2-105. 2-106 sets forth agreement, cancellation, conforming, contract for sale, termination. 2-107 discusses severance, and 2-501 discusses identification and fungible, which stands for substitutable, replaceable, and not unique. Part 2, the basic scope rule. Section 2-102 defines the types of transactions that are within Article 2 scope and identifies excluded transactions. In addition, over time, complex transactions that involve both goods and services led to the development of a body of case law that provides a more sophisticated analysis of such transactions. Legal analysis should dispose of scope and exclusions in one or two sentences unless an issue is presented. It is surprising that many lawyers in court still miss the fact that Article 2 applies to transactions in which they are involved. A quick scope analysis would prevent such an error. If the issue is presented, it deserves full analysis. Even if a transaction does not fall directly within the scope of Article 2, a court may apply code principles by analogy. Be prepared to explain the appropriate analogy if you want to convince a court to so apply the code. Section 2-102 provides a general rule regarding when Article 2 applies. The general rule is that Article 2 applies to transactions and goods. The rule has two elements, goods and transactions. 2.1, goods. Article 2 defines goods as things that are movable at the time of identification to the contract for sale. This definition requires an understanding of the concept of identification, which we will study in more detail later in this course. The key to understanding the definition of goods for purposes of a scope analysis is that the emphasis of the inquiry must be on whether the property, the goods, that is subject of the sale is capable of moving. It does not need to be movable at the time the parties enter into the contract. Indeed, the code contemplates different types of goods involving future goods and specially manufactured goods, which by definition will not even exist at the time of the contract. Real property is not goods because it is not movable. Distinguish dirt, which may be goods, but it can be picked up because it can be picked up and hauled away. Exercise 3-1 illustrates the importance of being able to determine when something is identified for purposes of a correct scope analysis. And there's an exercise for movable at the time of identification and relating to manufactured or model homes. Then there's section 2.2, transactions, which unfortunately, Article 2 does not define transactions. It is commonly stated loosely translating the statute that Article 2 governs sales of goods. However, as a matter of statutory interpretation, since the drafters used a word other than sales when they clearly knew that word, the title of the article is, after all, sales. Other commentators maintain that the scope of Article 2 is broader than just sales. Sales are certainly the main type of transaction to which Article 2 will apply. However, the use of the word transactions leaves the door open for a talented lawyer and a receptive court to apply Article 2 to non-sales transactions. Future goods, let me just give the footnote here, are goods that are not both existing and identified. And specially manufactured goods are specially manufactured for a buyer and are not suitable for sale to others in the ordinary course of the seller's business. Okay, mixed transactions, predominant purpose test, part 2.3. Article 2 does not apply to transactions that involve purely real estate or services. However, some transactions can involve a combination of goods and services, as in a contract to sell goods and provide maintenance services for a specified period of time. The goods and real property, as in the sale of a business that owns both real and personal property. Such transactions are commonly referred to as mixed or hybrid transactions, and the general rule based on case law is that you must determine what aspect of the transaction predominates. Specifically, after you determine that there is a contract involving both goods and services, you must decide whether the contract's predominant factor is 1, the providing of services with goods incidentally involved, example, contract with an artist to paint a painting, or 2, to sell goods with labor incidentally involved, example, a contract for the sale including installation of a stove. This test essentially involves consideration of the contract in its entirety, applying the UCC to the entire contract or not at all. In other words, if the predominant purpose of a transaction is to sell goods, Article 2 governs the analysis of all of the legal contract issues with respect to that transaction. The predominant purpose of the transaction is to provide services. Common law governs the analysis of all of the legal contract issues with respect to that transaction. The difficult issue in these types of scope analysis is determining the predominant purpose of a given transaction. Many courts have addressed the issue in a cursory or conclusory manner. Courts that have given a more thoughtful analysis of the issue generally look to the language and circumstances surrounding the contract, the relationship between the goods and services, the compensating structure, and the intrinsic worth of the goods provided. These courts consider the factual circumstances surrounding the negotiation, formation, and contemplated performance of contract. Figure 3-4 summarizes the variety of factors the courts have considered and weighed to determine whether the thrust of or purpose of a particular transaction was more likely goods or non-goods. So the things stated already before getting to the table is the language and circumstances. Circumstances are not in here, in the table, that is. The relationship between goods and services, also not in the table here. Compensation structure is not in the table, but you've got allocation of price in the table. Intrinsic worth of the goods provided is not included in the table, but that may be part, again, of allocation of price. So this table of factors courts use to determine predominant purpose contains contract provisions, language of the contract, and this is, for example, does the contract use the word goods or does it describe services? Language, particularly reflecting a sale of goods, would include buyer-seller agreement to purchase, whereas for services, there's design, contract, contract for work, labor, services, and materials, special skills, labor, business of seller, importance of who sells the goods, sales tax, and allocation of price. So for sales tax, if it's charged, it's more likely a sale of goods. If it's not charged, it's more likely the provision of services. The business of seller is another easy one, involves sale of goods, whereas the business of the seller involves provision of services. Labor is little labor involved in the contract when you have a sale of goods. However, there's significant time spent producing the goods and the provision of services. If I had not read special skills, it's the creation of goods did not require special skills or services, whereas in the provision of services, contract required special skills, particularly professionals such as doctors and dentists. The importance of who sells the goods. For the sale of goods, contract reflects that buyer was more concerned with the goods and less concerned with the installation, either who would provide it or the nature of the work based on the recitals and details of the contract. For a provision of services, the contract reflects emphasis on expertise and experience of the company who is providing goods and details of what that company will be doing based on recitals and details of the contract. Last in this table is allocation of price. Price is allocated on a per unit basis, or more than half of the price is allocated to the goods portion of the contract. In the provision of services column, the allocation of the price, if more than half of the price is allocated to the services portion of the contract. 2.4 mixed transactions also has a gravamen test. A small minority of U.S. courts has formulated the gravamen test as an alternative test for determining the applicability of Article 2. In a mixed contract involving both goods and services, this test seeks to determine whether the aggrieved party is complaining about the quality of the services rendered or the quality of the goods delivered. If the complaint is about the goods, Article 2 will govern the analysis. If the complaint is about the services, the rules of common law contracts will apply instead. 2.5, other scope analysis. In limited circumstances, legal scholars and courts have also applied Article 2 to transactions that do not involve the sale of goods, justifying their application of Article 2 rules on policy grounds. Alternatively, they will use Article 2 rules stating that the transaction before the court is analogous to a goods sales transaction, and the Article 2 rules are therefore helpful to apply. There is an exercise 3-2 to read True North Composites LLC versus Trinity Industries Inc. That started on page 30 and ended on page 35. Part 3, other bodies of law applicable to sales problems. Although this course concentrates on UCC Article 2, sales students should be aware of some of the other bodies of law that may be applicable to transactions and goods. First, as has already been discussed, where Article 2 does not specifically displace common law principles of law and equity supplement its provisions. Second, some transactions of goods are leases, whose analysis is now governed by Uniform Commercial Code Article 2A. Third, because Section 2-102 specifically provides that Article 2 is not intended to impair or repeal any statute regulating sales to consumers, farmers, or other specified classes of buyers, students should be aware of the need to determine whether any such laws are applicable to a given situation. For example, in California, the Civil Code contains a wide range of consumer protection law, particularly in the area of warranties. A lawyer in California with a consumer client who has a sales warranty issue would therefore have to consult the applicable Civil Code provisions in addition to California's version of the Uniform Commercial Code. Almost every state in the U.S. has some special protective legislation affecting particular classes of buyers. Another state law that might apply to supplement the code's provisions in a transaction in goods is the Uniform Electronic Transactions Act. Since Article 2 was written before the advent of electronic contracting, this law helps fill gaps that would otherwise make application of some of Article 2's provisions difficult when such transactions are involved. As of January 2011, only 3 states, Illinois, New York, and Washington, have not enacted UETA, and these states have their own statutes governing electronic transactions. Applicable federal law will also supersede UCC provisions in some instances and supplement the UCC in others. 3 examples are the Federal Magnuson-Moss Consumer Warranty Act, which we will study later in this course, the Federal Arbitration Act, which must be consulted if a sales contract has an arbitration provision, and the Electronic Signatures in Global and National Commerce Act, e-sign. Finally, in some cases, if the parties to a sales contract are residents of countries that are signatories to the United Nations Convention on Contracts for the International Sale of Goods, the CISG, the rules of the treaty may govern the transaction. As you can see, in practice, the lawyer cannot confine her analysis of a sales problem to the Uniform Commercial Code. Exercises 3.3 through 3.5 give you an opportunity to apply what you have learned about the UCC's basic scope provisions. Then return to the chapter problem, which gives you a more complex fact pattern, raising the mixed transaction rule and requires a more sophisticated analysis. There are 3 more exercises to this chapter and additional resources before moving to chapter 4.